Welcome to my channel. Please like, comment, and subscribe. In this video, we are going to talk about can you file a claim if you are at fault for your own maritime injury? If you sustain a maritime injury, determining fault is a complex legal process. Maritime or maintenance and cure attorneys can help you pursue a claim for compensation under specific laws to protect workers injured at the sea. If you are injured in the service of a vessel and in general with personal injuries, do not assume no one was at fault but yourself. In the shock of following an injury, try to avoid taking blame on yourself and seek sound and legal advice before signing any agreement to share fault for an accident. There are also maritime laws providing compensation for maritime workers that are no fault, including maintenance and cure. Let's explore how liability for maritime injuries is determined, compensation under the Jones Act, the legal concept of comparative fault, and the details of maintenance and cure for all maritime workers. The next discussion is about determining fault and liability in a maritime injury case. Under maritime law, ship owners are responsible to provide a safe and seaworthy vessels that is properly designed and maintained. Safety practices must be in place, defective or missing equipment must be replaced or repaired, and all crew members must be properly trained. If the owner of your vessels fail to meet these requirements, they may be held liable for your injuries. In general, injuries that occur on vessels in navigable waters will fall under maritime law and are tried in maritime or admiralty court. Local and state laws may not apply and workers' compensation is not available. If a ship owner had a duty to protect you from harm and that duty was breached and caused you injury, you may have a case under the Jones Act or other federal legislation. How the Jones Act protects maritime workers. The Jones Act allows workers who were injured on a tugboat, ferries, cargo ships, fishing vessels, and even offshore platforms to file a personal injury lawsuit against the owner of the vessels. As long as negligence was a factor in causing the accident, the injured seaman will be eligible to recover damages, which include pain and suffering, lost wages, future medical expenses, and disability payments. Of course, every case is different and maritime law is a complex. Even if you think that you are not covered under the Jones Act or other federal legislation like the Longshore and Harbor Workers' Compensation Act, it will probably benefit you to speak with an experienced maritime attorney before you sign away your right to sue or before the statute of limitation expires for your case. And then the next discussion is about what evidence is considered in a maritime injury claim. The circumstances that led to accident may be more complex than you realize. With an investigation into the details, evidence can show that the vessel's owner had a duty to protect you from the kind of injury you sustained. Some of the evidence that can make a difference in this kind of case includes where, when, and how the injury occurred. If the vessel was unseaworthy by the legal standards, if a crew members lacked a safety equipment and training, if the ship was operating without the required number of crew members, if a crew members were fatigued or overworked, and then if equipment in use on the vessels was properly maintained and appropriate for its purpose, if appropriate medical care was provided before and after the injury. And then, if ship owners or other crew members knew or should have known that unsafe condition existed. And then the next is how comparative fault may affect your claim. Maybe you did, in fact, share in the fault for your accident. Even in these cases, maritime law allows you to file a claim if another party was even partially at fault. Ship owners and their attorneys will often try to persuade you to take part of or all of the blame for an accident in order to reduce the amount of damages they may be required to pay. Each party will be responsible for a percentage of the total damages if more than one party is found to be at fault. If possible, avoid making recorded or written statement where you might blame yourself for the accident. While manufacturers might have combined to cause your injury, many or most of those will fall under the vessel's owner duty of care. A ship owner's level of responsibility to maintain a seaworthy vessels and a safe working environment is considered higher than that of an individual crew member who is following orders. The right to maintenance and cure is no fault. Even in the unlikely event that you were entirely at fault for your own maritime injury, you may still be entitled to the legal right of maintenance and cure under maritime law. Under these ancient and still active requirements, vessel owner must provide these remedies to workers injured in the service of their vessels. And then maintenance. Maintenance in this context means reasonable room and board while the injured worker recovers at home. Many times vessel owners try to limit this charge to be a basic rate of $15 to $13 per day. Many cases have successfully argued that this rate should cover rent and mortgage payment, utilities, transportation costs, and food. Maintenance continues until the injured person can return to work or has reached maximum medical improvement. And then the next is cure. In this context, cure is understood as reasonable and necessary medical expenses and the transportation cost to receive that treatment. Covered medical care must be curative in nature, but you may choose your own physician to provide it. You are not required to use a company doctor to establish when you have reached maximum medical improvement or MMI. When you have returned to work or reached MMI, your right to compensation for your medical expenses will end. And then the next discussion is about fire compensation for maritime injuries. The unfortunate fact is that not every ship or platform owner is fulfilling their duty to provide a seaworthy vessels, well-trained crew, and well-maintained equipment that provides a safe working environment. Some will even try to limit or refuse to pay basic maintenance and cure. With so much at stake, injured maritime workers should consider a free consultation to discuss their recent injuries. I think that's all, guys, the information that I can share to you. Thank you so much for watching. And if you need information about maritime topics, you are in the right channel. Because in this channel, we talk about it a lot. And if you want us to talk about or discuss about the information that you need about maritime topic, you can drop your comment below in the comment section, and later when we have a chance we will talk about it. And then do the same thing if you have a question. You can also drop your question in the comment section, and later when we have the answer and time we will answer your question too. And don't forget to share this video to your friends, a family, and your loved one. Maybe they need information about maritime topics. For example, maybe they need information about LHWCA, or maybe they want to know about the Jones Act, about death on a high seas act, or maybe they want to know about a maritime lawyer in the region. So you can share this video to them when they need help. So when you share this video to them, it means you already helped them to get through the problems. I think that's all the video that I can share to you guys. I hope you like the way I deliver the explanation to you, and I hope you can take advantage from the video that I have shared to you. And thank you so much for watching. Don't forget to give like, comment, and subscribe. Bye. Welcome, not welcome. Bye bye. See you in another video.